Thank you very much for coming along tonight. My name's Glenn Hanson. I'm a partner here at Hesketh Henry in our construction team. So it's my pleasure to welcome you here to Hesketh Henry. My role is pretty simple. The toilets are through the door here and then to the left. And in the event of the fire alarm going off, please follow one of the staff from Hesketh Henry who will show you where to go. So really looking forward to the presentation tonight, and I'll hand over to Vimal to speak on behalf of the SCL.
Thanks, Glenn. Tēnā koutou katoa, nau mai, haere mai. Welcome everybody to the SCL function. Good to see a packed room here tonight. Sure there's a lot of interest in this very popular topic, and I really look forward to what the panelists have to say. For those who are online, welcome. Our hubs in Hamilton, Dunedin and Queenstown. Also like to thank Hesketh Henry for hosting it. Really very much, SCL very much appreciates the support. Welcome to our non-member guests, as well as those attending online and those actually attending for the first time. Really appreciate your support. For those online, could you please mute your microphones and turn off your cameras to avoid any interruption? If you wish to ask a question, use the Q&A function on the chat. We will hold questions to the end of the presentations to avoid interrupting our speakers. Before we move on, a couple of SCL notices. Our April meeting was the lunchtime webinar discussing interesting case law. A recording of that is now in the members only area on the website. For those of you, if you have a topic you'd like to present at these events, please do not hesitate to get in touch with us. We always welcome speakers of interesting subjects. Please get in touch with Manager Melanie or Jonathan Forsey, our Honorary Secretary. In terms of next meeting for the SCL, please note that in your calendar, 20th of June is our next meeting. It is going to be on a panel event on infrastructure funding and finance on large projects in New Zealand. It's going to be a panel discussion, so hopefully we get, we've got some really good panelists, so it will be a really useful event. This will be an in-person event in Auckland, which will be live streamed. Notices will come out soon, so please keep an eye out for it. On the 24th of July is our AGM and annual dinner. This is being held at the Fable Hotel here in Auckland. Formal notices for that will be issued soon, so keep an eye out for that. It's a good evening, so please make an effort to attend. Now on to this evening. It is with great pleasure for me to introduce our esteemed speakers. We'll go from our left to the right. Helen Macfarlane, as most of you know. She's a Vice President of the SCL, and she's a partner here at Hesketh Henry. Helen's construction practice includes full panoply of front-end drafting, advice, and project issues during construction and dispute resolution, including defective design, construction claims, and CCA adjudications. A recent highlight has been representing the design JV in a High Court proceeding alleging defective tender design in relation to a major roading infrastructure project. Next is Christina Bryant. She's a litigation partner here at Hesketh Henry as well, appears regularly as counsel at High Court and appellate level. A practice focused on complex civil claims, primarily in the construction, property, and insurance sectors. She's a faculty member of the NZS Litigation Skills Program and an associate of Ammons. Last but not least, Kelly Quinn. Kelly is a barrister at Bankside Chambers, an experienced trial advocate with extensive High Court experience practice. He is highly regarded for his expertise in contentious construction matters, having acted in matters involving a wide range of construction law issues. Of particular relevance to this seminar, Kelly was counsel for the successful head contractor claimants in 2 recent High Court trials. Both cases were of defective or non-compliant tender design in a design and build context. Please welcome the 3 speakers.
Sorry. Well, I'm going to turn the microphone off and just bellow, because that at least frees up my hands. All right, in recent years, there have been a number of disputes where contractors have been alleging negligent tender design against consultants. Some of those cases have proceeded to trial, like, for example, the recent CPB v WSP case relating to the Southern Corridor Improvement Project, which Kelly is going to be talking about later. Others have settled before trial, like, for example, the transmission gully matter. But a number of issues run through many of these cases, and we're going to focus on some of the key issues tonight. The first set of issues we're going to be focusing on is risk allocation and risk management in the tender design. The second that we are going to be focusing on, and that is what Kelly is going to be talking about, is the nature of contractor losses. What is the contractor's loss for a defective tender design that then has to be changed during the detailed design phase? And finally, Christina is going to talk about limitation clauses, including both limitation of liability and your frequent clauses, excluding consequential loss, loss of profit, etc., and talk about cases indicating what is working and what is not. So, to get on with things. Oh, what's happened here? There we go. All right, tender design risk. Let's look at it first from the contractor's perspective. The contractor will say, I'm going to put all of these up. There we go. The contractor will say, consultants have the design expertise, not us. They're the experts in doing the design. And we expect to receive from them during tender a design that we can price, that we can then go ahead and build for pretty much what we've priced it for, and isn't going to have massive changes. Another way of putting it is that we're going to get a compliant design that complies with the specifications of the project, except where we've tagged it out or we've sought departures. And that we can we'll build that at the price that we have been able to quote, to estimate. So it may need refinement, but it mustn't fundamentally change, because if it fundamentally changes, then I price something different and it's just not going to work. That is the contractor's perspective. All right, consultant's perspective. All right, the consultants say, okay, sure, fine, we're the experts in design, we provide a design, but you know what we don't do is we don't price. And in fact, in most tenders, pricing is actually a very closely guarded contractor secret about, you know, consultants are not brought into that. So they are typically excluded from pricing discussions. So they have no idea of the contractor's commercial decisions, the contractor's approach to risk, and for all they know, the contractor may be underpricing the risk of tender design change. So that's the consultant's perspective. You know, we're being asked to do a design, yeah, but we don't know what is going into the pricing here. That's a risk. That is our unknown. So how do you manage these risks? Well, there are a number of tools. Contract, insurance, and what I think is really, really key in the tender process, risk identification. So turning to contract, first of all, from the consultant's perspective, you have limitations of liability. That is caps and consequential loss. I'm going to skate over that because Christina is going to be dealing with them. From the contractor's perspective, you have warranties, indemnities, contractual standards of care. These are all provisions in a contract that will protect the contractor. Now, first of all, we're going to take a look at a couple of warranties which are in the cases that Kelly is going to be discussing. The first is the warranty in H infrastructure and Worley, where the consultant warranted it would perform the tender services in full compliance with the principal's requirements and carry out the tender services in accordance with Schedule 2. And Schedule 2 then involved developing the tender design sufficiently to allow costs, risks, and constructability to be identified, optimized, and priced. This was a pretty extensive warranty that was given in the H infrastructure case. Turning on to the CPB v WSP consultant warranties, this is a somewhat narrow warranty. The consultant has and will provide the requisite professional skill, expertise, experience, and resources necessary to perform the preliminary services. And the preliminary services, of course, included the design services necessary for the contractor to submit the tender. Now, the key thing in that particular warranty was that the consultant wasn't just warranting that they had the professional expertise, they were warranting that they were going to provide the professional expertise to do all of this. So if in fact the consultant was negligent, then that would be a breach of their warranty that they would provide the relevant professional expertise, because obviously they weren't. That is sort of the key element in that particular warranty. So although it is much narrower than the warranty we saw in Worley, it still gives that hook to be warranting outcome. All right. One of the things we need to be aware of when you are looking at contractual warranties, standards of care, and indemnities is how they will fit with insurance policies. Most insurance, professional indemnity insurance policies have exclusions for contractually adopted obligations that provide for a higher level of responsibility than you would otherwise have at common law. And warranties are actually quite a good example that you can run into difficulty with, because warranties actually have strict liability. If you're in breach of warranty, that's it. You are liable. So none of the sort of normal negligence standard would apply. If you've warranted this, doesn't matter if you were negligent, you've warranted it. You're liable. That can, where you are warranting outcome, that can impact your insurance. Higher than normal standard of care. You know, we've all seen these clauses that say, you'll use a higher standard of care used in your profession. Again, that is higher than the normal tortious standard and could prejudice cover. And then you have indemnities that override, and this is just one example, an indemnity that overrides contributory negligence. Again, contributory negligence is something that you would normally be able to rely on at law. And so if you're contracting out of that, again, that is something that could implicate an insurance policy exclusion. So the comment I simply want to make with all of those, and this is for both contractor and consultant, it is in nobody's interest to prejudice insurance cover. It's not. So don't have clauses that may do that. The other thing that you really do need to do is get insurer sign off on both the tender services agreement and the design services agreement. Usually, if you're getting a project-specific PI, that will be happening at the time of the design services agreement, but get them and will then be retroactively effective to the start of the tender. But the insurer needs to sign off on both. I'm going to skate over insurance because I've already talked about it a fair bit. It is something that is frequently ignored. It can be the consultant's general PI, or it can be project-specific PI. It can sometimes be multi-layered with primary and excess. You need to, if you have two levels of insurance, just make sure they work together. And again, I think the key thing that I am telling you is get your insurers to take a look at your contract and let you know if there are any clauses in there that could prejudice cover. All right. Risk identification. Now, the tender design is usually between 20 and 30%. It's actually slightly shy of 30% IFC because in detailed design, frequently your first stage is your 30% design. So your tender design is usually, say, 20, 25% of issued for construction, final design. So it needs developing. But the question is, where does design development end? And where does design error begin? Okay, there can be a number of ways in which a tender design can change. First of all, you know, what was in the design may not be able to end up being built. And so you have to actually have a total change in design. So for example, you design an arch bridge. It turns out that actually, after you've done all your analysis, that isn't going to work and you need piles instead. That is a total change in concept. Or it may become much more expensive to build due to modifications to the original design. Okay, so say you have some piles, but maybe they need to go deeper than you had actually thought they need to do. Or maybe they end up getting much, much bigger and having sleeves get put on. All of that, particularly changes in size and depth, can have a significant impact on the cost of the design because it can frequently need totally different equipment and a totally different construction sequence. So it can have a big, big impact. And then you can have a change that can be just a bit more expensive to build due to design changes. Now, any of these can occur through a couple, well, I'm identifying two things. One is actually a design technical error. For example, a calculation error using the wrong standard. Or it can be that design assumptions are made that turn out to be incorrect. Now, assumptions are made when there's lack of technical data, or there are things you don't know. For example, and this is one of the typical areas where this happens in New Zealand, and you will see that in one of the cases that Kelly is talking about, is lack of geotechnical data. You know, particularly in roading infrastructure projects, you might have boreholes near where you need them. It may be inaccessible. You're in a very compressed time frame. You can't get all of that geotechnical data that you actually need. So you have to make assumptions based on what you know about what the land is going to be like below where you're doing your design. This is a problem that occurs in multiple projects in New Zealand. And the thing is, and that everyone has to remember, contractor and consultant, if you do not have all the information you need, it is possible to make a reasonable assumption and still be wrong. So, how do you handle that? Well, do you go conservative or not? One way of handling this, and again, this is unknowns, lack of information. Make the most conservative assumption possible. Now, consultants are typically going to like that because by and large, I will say consultants are a pretty conservative bunch. And, you know, typical design has a lot of conservatism built into it. Contractors will not like that at tender. Why? Because the more conservative the assumptions, the higher the cost is going to be. And, you know, one of the things you're wanting to do at tender is do a compliant design, but at as low a cost as you can possibly do because you want to win the tender. So, here is an alternative. And that alternative is to make what in the consultant's professional judgment is a reasonable assumption, so it can't just be a random assumption, but a reasonable assumption that is supported, and one of the risks that the assumption may be wrong and the possible consequences to the design and the construction if it is wrong. I call this the principle of non-conservatism. It allows the contractor to price on the reasonable assumption and add contingency for the possibility of that assumption being wrong. Now, is it a legal principle? It is something that just is done by nature of the tender process. And it must inform risk identification during tender. I mean, this is something that happens on tenders throughout this country. And therefore, it must inform the risk identification during tender. So, how do we do that? First of all, ask yourself, are there unknowns at tender time that could result in changed design? Consultants and contractors. In some cases, the answer may be no, but I'd be a bit dubious about that. I would imagine in most cases, the answer is going to be yes. All right. Acknowledge it. And I have seen a number, in fact, of TSAs that expressly do this. They say that, words to the effect that given the short time frame, whatever the unknowns are, it may be that the consultant will be unable to create a compliant design. And if this happens, even if they use the contractual standard of care, and if this happens, this is going to be damaging to the contractor. And therefore, the consultant has an obligation to identify risks. So that's sort of spelling out that principle, what underlies that principle of non-conservatism. So that can be done in the contract. The second thing you do is you have to have a formal process for notification of risks. And that is going to take, oopsie, wait a minute, gone too much there. There are two elements to that. One is risk register and one is pricing packages. Okay, what goes in what? Your pricing package is your package for a particular component. So, it might be a particular bridge or group of bridges. It might be your cutting and filling. It might be your pavements. And the risks that will affect the pricing of that particular package should be included in the pricing package. Have a cover page that just it calls for identification of risks so that it is there in your pricing package. The risk register tends to be a little bit broader, although it normally will actually include package-specific things as well, but it goes a bit beyond that, and it has things that will affect the overall project. Like, you've got a gas main really nearby, and if anything goes wrong and that explodes, you have major problems for the whole project. So it has more project-wide risks on it, including, for example, consenting risk, again, which could affect multiple areas, private land acquisition risk for highways. All of that are things that are going to not be affecting particular aspects, but will be affecting broadly. But if in doubt, put it in both and be over-inclusive. And one thing I would say, it is really critical because your pricing package, that is what goes to the estimators who are the primary people who are responsible for pricing that package. It is really important that they actually have all the risk information that might affect that package because they can then take it into account in their pricing, as opposed to just leaving it for the risk register where you sort of have somebody sitting on top at the end making an assessment of design creep, of the extent to which the risk allocation you're going to make for increase in design costs. You really need to get it in, I think, at that early stage. Don't exclude it from the risk register, but do really include in pricing package. So you warn of the nature of the risk, potential design, and the cost impact. And in Worley, although that was not necessarily something that the case turned on because it was a breach of warranty case, the judge did comment about the fact that the contractor the cost increase was very substantial and that the risk of that substantial increase had not been notified. So it is important to not just notify of the risks of design change and what the design change may be, but that it may have a cost impact. Having said that, right, the nature of what that cost impact is really up to the contractor, because you can tell the contractor, look, and again, let's go back to our piles example. The piles are going to get much bigger and could go deeper and they might need sleeves. That's going to could have a substantial cost impact. But it's going to be the contractor that knows, yep, for a piling this size, I'm going to need this piece of equipment. For a pile this size, I'm going to need that. But, you know, this may change the sequence. That's all going to be within the contractor's knowledge, not the consultant's. But you've got to give the contractor enough information for that to be going through their head. So don't let things fall between the cracks or on the side of overwarning. And it is tough in a tender, I know, because you have a very short time frame and you're not being paid nearly enough for the amount of work that you have to do. Document. Never rely on oral warnings, only because they may not go to the right person. And if they do go to the right person, that person might not remember. So, this is not going to eliminate consultant risk of not being part of the pricing process, nor is it wholly going to eliminate design change risk. But it will make it more likely that the contractor is going to be given the necessary information to make a good pricing decision. And it will also, from the consultant's perspective, ensure that the consultant has good evidence of warnings if things do turn to custard and a claim is made. So that is my little part ended, and I will now turn over to Mr. Quinn. And I will not this time take away the clicker, which is what I did last time. Get for it?
Yep. Thanks, Helen. Good evening, everyone. Thank you to Heska Henry for hosting, and thank you for inviting me to be part of this. You didn't need to do that, so it was very generous of you, really. It shows the way in which the law community operates. We might have scraps against each other from time to time, but we can still talk civilly about our different views occasionally on the same cases. And I'm here to talk about two of those cases tonight. Two, in my view, marvelous decisions where extremely knowledgeable, learned and wise judges have delivered judgments of rare insight and perspicacity. Those decisions were, in my view, unquestionably correct, and just coincidentally, they happen to be in favor of my clients both times. So the first one is, just before I get into the cases, I suppose I'll show you this slide, which I'll be coming back to actually. One of the things that's quite useful about the two cases is that they demonstrate at least what on the face appears to be quite different approaches to the way you go about calculating your loss calculation, even though both cases are concerned with instances of design error at the tender phase of a design build project. There's reference there to different approaches or bases on which damages may be awarded in a contractual context, restitution, reliance, and expectation. I won't say anything more about that now. I'm going to come back to it. One thing I'll say is that, and this is emphasized by Justice Johnson in the CPB decision, is that it's for the plaintiff to choose the basis on which the plaintiff wants to calculate its loss. still have to prove it, but they get to choose the basis on which they bring the case to court. We'll come back to that in a moment. Let's go first of all to the Hawkins Infrastructure, which became H Infrastructure Limited, and Worley decision, which was delivered by Justice Peters in 2022. If it wasn't nighttime, we could look across the harbour at the Devonport Naval Base, and you will see there, it's still there, the barge that's in the right-hand side of the photograph. And what that is a seamanship training aid, which the Royal New Zealand Navy wished to have built to mock up, if you like, a naval ship. And the idea was, you can't see really all of the barge there, but it's a couple of decks to it. And although it's just a floating box, essentially, the idea is that it has some critical componentry on it that's just like what you'd have on a ship. And it's floating, so it's rocking about just like ships do, and they throw cadets off and rescue them and do fancy stuff like that to help train their young sailors who are fresh out of school, presumably at 16 or 17. They called for tenders, and I think there were 3 or 4 tenderers, perhaps 4 tenderers, who were required as part of the design. So it's a design-build contract. Part of the design was required to provide for mooring of the barge there at Devonport. It needed to be able to be removed, to be taken away for maintenance from time to time, but it was otherwise to remain moored there, and it needed to withstand the tide and wind conditions that it'd be exposed to from time to time, and obviously not tear away from its mooring. The other tenderers, all of the other tenderers, not my client, and their design consultants came up with a 3-pile solution for mooring the barge. My client, Hawkins Infrastructure, assisted by its design consultant Worley, had a 2-pile design. Hawkins was successful with the tender, was awarded the contract, and then work started on the detailed design phase. Very early in that detailed design phase, Worley recognised and self-reported that the 2-pile system, as it was designed at the tender phase, was not going to work, wasn't going to comply, and it needed to be altered. And what they altered it to is the truss system that you can see there underneath the gangplank. You can see several beams that comprise, or parts of them, that comprise a truss that was used to connect the barge to the 2 piles, which was a different solution from what was originally proposed. Originally, the barge, one end of the barge was going to be hard up against the 2 piles and just rising up and down them on sleeves. This is a much more complex solution which held the barge away, separated from the 2 piles, and the truss flexed and was articulated in every possible different direction with universal joints and all the rest of it, and reasonably complex. One of the big issues in the case was whether Worley, under the terms of the PB TA, I think it was, the pre-bid tender agreement, something like that. The TSA would more generally call it, the Tender Services Agreement, whether Worley was obliged to comply with the Navy's requirements, the principles requirements for what the barge would or wouldn't do in certain weather conditions. I'm not going to speak any more about that other than to say, obviously, it was resolved in favour of Hawkins. There was such an obligation on Worley, and that's regardless of the fact that one might typically expect a tender design, as Helen said, to be at about 20 to 30% of full design development. Still, the obligation was to comply with the PRs because, long and short of it is that Worley warranted that their tender design would comply with the principles requirements. The tenders were all closely grouped so that if we wanted to take the approach that you'll hear about in a moment that we took in CPB, that, well, if you'd if you'd provided us with a compliant design at tender, perhaps 3 piles or perhaps including the truss as was eventually built, if you'd provided us with that design at tender time and we'd priced that, there's a good chance we would have been up beyond some of the other tenderers, so we wouldn't have won the job. So this is an example of what I mean about us choosing the basis on which we bring our claim for loss to the court. What we said instead was, and I mean, it's quite logical really, what we said was that our loss was the extra cost that we incurred in constructing the truss system and the modifications that had to be made to the barge to accommodate the attachment of the truss to the barge. A few other things, well, I mean, Hawkins said there were about that many losses and they were all most of them were challenged by Worley and some were disallowed by the High Court. But certain obvious changes such as the truss itself and the cost of painting it, the attachment points and the arrangement right at the essentially the bow of the barge, those kind of things were allowed for. You got to remember that, of course, having been presented with the 2-pile, the original very simple 2-pile mooring design, we were then awarded the contract with the Navy for a lump sum price of about $4 million, I think, something like that. When the problem emerged and was recognised in respect to the mooring design, and in fact was that it had to be changed, of course, the Navy is able to say and did say, well, we haven't changed anything. You promised on this design build contract that you would deliver us our barge safely moored at Devonport, and you would do that for $4 million. And so you still got to do that. And, I mean, they were quite right in taking that approach. There was no question that there could be a variation or anything like that. So we were bound to produce a working barge and one that wasn't going to drift off into the shipping lanes during a storm. And so to do that, we had to build the revised design with the truss and all the rest of it, and that cost us, we said, quite a bit of extra money. So that's the Worley case, Hawkins and Worley. The next decision that I'm going to talk about is this very recent one. A decision was delivered just before Easter this year, which concerns the Southern Corridor Improvement Project on the Southern Motorway here in Auckland. Some of you will know that from the Manukau interchange south to the Takanini interchange, it's about 11 kilometres of motorway, there was a multi-year project to widen that to 3 lanes on both sides. Big job. There were 4, I think, tenders on that job as well. It was a design construct, design build contract again. 4 tenders on that job. 3 of them were all clustered quite closely above 255 million. And CPB, my client, its bid was languishing down at 192 million. And surprise, surprise, they won the job. They won the job. They might wish they'd never won the job because they went on to make quite a loss on the job overall. I can talk about this because we led evidence on this fact and it's in the judgment. They made a total loss in the order of north of $40 million. And what the case concerned, of course, there were many components to this job. There were bridges to be built. There was drainage that had to go in. There was enormous amounts of earthworks and civil works and so on. And also, almost right at the end, as you can imagine, one has to pave the newly built road, the newly built lanes, either side of what was already there. And so part of the, and part only, of the design that had to be prepared for the tender was designed for the pavement. And many of you will know that paving roads are not a simple business. There are many ways to skin that cat. And the pavement is made up of 6 or 7 typically different sandwiches of different materials. And there were principles requirements from NZTA, from Whakatahi, setting out in quite astonishing detail, really, at least to my eyes, what they wanted the pavement to look like. They had these kind of requirements, of course, for the whole project, but they were quite particular about certain aspects of the pavement design and how one was to go about that. So there was an argument in this case as well, just as there was in HIL and Worley, there was an argument about whether the tender design had to comply with the principal's requirements. Again, that was resolved in favour of CPB. One factor that's worth noting there is that WSP was paid, including success fee, it was paid $2.5 million for the tender design in this job. So you might think prima facie it was a difficult argument to run that we were paid $2.5 million to prepare a design that didn't have to comply with Waka Kotahi's principal requirements, and that argument was rejected. Now, the interesting part of the judgment for tonight's purposes is what was CPB's loss? And there's a couple of key facts here that I need to tease out. The first is completely unlike the Hawkins and Worley case. There wasn't some discovery early on in the course of construction to the effect that there was anything wrong with the pavement design. CPB didn't end up building the design as it was prepared at tender stage. The design that's now shown in the as-built and the IFC drawing is different from the tender design. But what CPB discovered late in the project was that there had been an error made, actually several errors made, in the pavement design that was prepared by WSP. And what they realized was that, one of these errors is quite serious. If you feed the design as prepared at tender stage, if you feed it correctly through the circular modeling that's used for pavement design, mechanistic algorithm that's used for pavement design, if you feed all the relevant parameters and the variables through that kind of modeling, what you get for the design that was provided to CPB at tender stage, using the expected traffic movements that were provided by Waka Kotahi, the design was only good for 1 year, not 25 that were required. So we're not talking about trifling errors here, it was quite serious. And what CPB realized was that if they had been given instead a compliant design, one that was based largely upon the design that was provided by WSP, but altered in the least ways possible to get it to a compliant stage, if you took that design and fed it through their pricing machine using otherwise all the same geometric assumptions and data and all the rest of it, so that the errors of any risk still lay with CPB, risk of any errors, they would have bid $5.3 million more. So what they said was, if you'd done what you undertook to us that you were going to do, which is give us a compliant design, one that matches PRs, our bid would have been $5.3 million higher. Now remember, there's that massive delta between CPB's bid and the next lowest bid out of the other three tenderers. So our contention, and it wasn't really disputed by the other side, was if we'd bid another 5.3 million higher, we still would have won the job. Sort of follows, given there's 67 million or something of daylight there. That way of approaching the loss, although at least to my mind it seems quite logical, is not one that appears to have been followed before in New Zealand and been rejected either, but it just hadn't come up in any decision that we could find. And in the UK courts, we could find only one decision where anything comparable had happened. And it's this case from 2009, Costain and Charles Haswell. I won't read out the quote, you can read that for yourselves, but very briefly, the facts in Costain were that there were, again, design build contract, several buildings to be built on this one site, and Costain, the head contractor, used Charles Haswell as its design engineering consultants. Some of the buildings were piled foundations, but for one building in particular that was an issue in this decision, Charles Haswell had said, what we'll do is just pour a raft or a slab for the foundations for this building, that'll be fine in that particular spot of the site. The principal's requirements in this instance had insisted that there be differential settlement within certain specified tolerances, small amounts of differential settlement across the footprint of any given building on the site. In order to ensure that that was met, what Haswell specified was that Costain should preload the footprint for this particular building by putting in fill on top and letting it sit there for 6 months, something like that, then take it off and go ahead and pour the slab foundation. But when they did that, they took the engineered fill off and found that they still weren't achieving what they had thought and hoped that they would achieve in terms of differential settlement on the site. It was really quite markedly in excess of the specified tolerances. And they did a bit more investigation than perhaps they should have done at the outset, and determined that the only way to deal with this part of the site, actually similar to other parts, was to use a piled solution for the foundations. So they changed the design. Now at that point, the new design did get built. Costain built the piled foundations for that building, and they said that it cost them an extra, I think, £170,000 more than what they had allowed for based on the design that was provided at tender. And it was Haswell, the engineers, who said, yes, well, that's all fine and good. Maybe you did spend 170,000 more, but if you'd priced this at tender time, if we'd given you a piled solution at tender time, based on how you priced the piled foundations and other parts of the site, we can see that you would have bid only around £130,000. And the judge agreed and said, yes, that's right. Therefore, if there'd been compliance at tender time, what Costain would have done is they would have bid an extra £130,000. And even if it did cost them £170,000 to build, £130,000 is the most they could have recovered. So we took that principle and took it to the slightly different, but not dramatically different, fact situation in CPB, and said, although we didn't end up building the tender design or any sort of direct variant of it, if you, WSP, had complied with your obligations at tender time, we would have bid 5.3 million more, even if it ended up, and we had other evidence that showed that we made not only a large, significant loss on the job overall, but also quite a loss on the pavement aspects of the job to the extent that we could untangle those. But what we were effectively saying to the court was our true loss here might have been in the order of 12 to 15 million. That's what we said about payment. A true loss might have been that high, but we're not going to waste your time, Your Honour. We're not going to waste your time by trying to prove that, because Costain is authority for the proposition that we shouldn't be allowed to recover that much. We should only be allowed to recover what we would have bid by way of increased bid back at the tender time if WSP had performed as they were obliged to. And that argument carried the day. That's it from me, a bit shorter and sweeter than last night, but you know, the benefit of thinking for 24 hours. Thank you. Look, I said that I was going to go back to the restitution, reliance and expectation slide, but I'll leave that for what might emerge, I think, during a bit of discussion to come.
All right, well, I will endeavour to maintain the bellowing, but if anybody at the back can't hear me, please let me know. What I'm here to talk about is one of the key protections which are available in contracts generally and typically in consultants agreements, but also contractors can make use of them too. Limitation clauses, and specifically from recent case law, what appears to be working and what appears not to be, although that is obviously dependent on your point of view. This is a set of clauses that will be familiar to most of you. It is the CCCS contract, which for some reason I have difficulty articulating. It's a series of limitations which address different things. The first up there, 6.1, addresses the type of loss which that you could recover for. The second is about caps on liability. The third is about a contractual provision which requires proportionate apportionment of risk and loss. And the third is duration. Today, I'm just going to talk about the top two. And I'm going to start with the, well, before I get into it, talk briefly about the benefits of having a well-structured and effective limitation clause in your contract. At the contract negotiation stage, these things are important for pricing risk. What a consultant or a contractor is prepared to price will determine or may depend on the scope of the risk. It may have issues in relation to insurability, which Helen has already touched on. And typically, at least the way the contract is set up, it is intended that the scope of risk and the scope of the insurance policy go hand in hand. And also it has the merits, hopefully, of providing the parties with some certainty about where risks lie and what the magnitude of those risks are. So that when they reach litigators in due course, if that ever happens, there is an inducement to settle because parties know again what is on the table and what is not. And if that doesn't happen, they can also provide the very useful tool of allowing us to enforce those constraints in some circumstances pre the hearing, the final substantive hearing. And there's a number of mechanisms by which that can happen. But the use of that is that the parties don't have to go through the full process in order to determine the scope of their risks. And it also has some advantages, I suppose, from a more psychological point of view. If you have to wait to a substantive hearing, you're asking a judge to go through a process where they determine liability, causation, and quantum, and then make a finding in your favour that a lot of that has actually been a complete waste of time. It's very difficult to do. And the psychology goes the other way. If you can determine it in advance, the judge has the opportunity to narrow the issues that will come before him or her in due course, and may even hope for an early settlement. So let's look at what's been working first. Liability caps are a good news story. They are effective so far between commercial parties. It's very important for you, those of you who are involved in residential construction in particular, that there are consumer protection exclusions, which typically are in the Consumer Guarantees Act and the Fair Trading Act. Although you can contract out if you are a commercial party, there is still an oversight by the court of what is fair and what is reasonable. And there is this maybe enforceable pre-trial benefit. As you'll see in a number of cases we're about to go, that's precisely what happened. So I'm going to start with the iSoft case, which is actually now quite dated. As you can guess from the background of the slide, this wasn't a construction matter. This was a sale and purchase of a software business, which had effectively profit share earn-out provisions as part of the purchase price. There was a preliminary hearing to determine whether or not a $5 million cap in the contract would apply. The cap was for the maximum aggregate liability, but there were certain carve-outs in relation to it. This is probably the high watermark case for the appropriate approach to limitation in a commercial contract. There is a truism that you'll have heard many times, no doubt, that clear language is required to exclude liability. The courts say they will not lightly assume that parties will give up rights. And there is, at least in the past, have been the view that if there is any level of ambiguity, effectively the limitation doesn't stand. What this case said is no, there is no inherent hostility by the courts to limitation clauses, and ordinary limitation provisions apply. So you go through the same process of looking at the words of the contract, what the contractual context is, what the contractual matrix is, and if there is an ambiguity, see if you can solve it. If you can't, you can fall back on the contra proferentum rule, which is basically a tie-break rule, which says that the party who is responsible for the lousy drafting is the party who bears the price of that. That, as I said, has been the high watermark. There has been a retreat to that to some degree, particularly in the consumer and in consumer insurance context. Importantly for tonight, in the Court of Appeal in this decision, What was at stake was whether or not a limitation clause could exclude a right to get discretionary interest from the court under the Judicature Act. So that was a statutory right. Could parties by their contract exclude it? And what the court said is yes, but it depends on the construction of the contract, of the statute, excuse me. Would limiting that right effectively undermine the purpose of the statute? The court said in that case, no. As a result, there was a $5 million cap, a hard cap on that contract, and the matter did subsequently settle. This leads us to the very interesting case which has come out recently of the Tauranga City Council and Harrison Constructure, which was all about whether or not limitation clauses could be used to limit liability effectively for a breach of the building code. What was at issue in this case was the construction of the Tauranga City Council's transport hub. So in this case, the council was the principal or the client, not the BCA. That's how they were suing. They claimed that as a result of errors in the structural design and a failure by the peer reviewer to identify those errors, it had suffered a loss of $25 billion or more for a breach of a duty to comply with the building code. And that was framed in various ways. It was framed in contract, it was framed in what they call common law duty of care, which is effectively negligence, and also more unusually as a breach of a statutory duty. There was also a claim that the producer statements, which said that it complied with the code, were misleading, and there were claims under the Fair Trading Act and for negligent statement. There were liability caps in the two standard form agreements which were being used, the CCCS contract, which was $2 million, and the short form agreement, which I'm sure many of you know is 5 times the fee or $500,000. And there were also caps in the standard form producer statements, which were used. The council argued that the limitation clauses were inconsistent with the duties that were owed under the Act, and they were therefore unlawful. They were illegal contracts, and they should not be enforced. Now, that's a big argument that will effectively, if it is enforced, apply to all limitation clauses, probably in vertical infrastructure and to an awful lot of structures in the horizontal infrastructure space as well. So what happened? It's been through to the High Court and a judgment came out very recently. The court accepted and agreed that consultants have a duty under the at law to exercise reasonable care and skill with a view to ensuring a design complies with the code. And you'll see that the standard of care being put there is the professional standard, if you like, a duty to use reasonable care, not to guarantee an outcome. The court said that parties indeed cannot contract out of the minimum standards imposed by the code, and that was a necessary consequence of the Spencer on Byron decision by the Supreme Court some years ago. But the judge said the Building Act does not exclude contractual limitations on damages claims. Other than warranties for household units, there is a provision in the Act which says you can't give the benefit of those warranties away. The judge applied quite an interesting analysis. She said, well, the council has a duty to comply with the code and the consultants have a duty to comply with the code. So what the limitation clause is actually doing is determining which of these people are going to bear the cost. So the consultants were going to bear the cost up to the limit of their liability, the 2 million, and I'm guessing around 75 based on what the fee was. And then the council was going to cover the cost above that. The caps in the standard form producer statements, however, did not apply because the council was suing as the principal, effectively the client under the consultancy agreements. That was the operative clause. So what we don't have yet under this case is a question of whether non-contractual notice will be effective to limit liability to a council. Now, I understand that this is under appeal. It's been informed through channels through chambers. So it's a watch this space on this one. But to date, this has been a success story for CAPS. They have been generally effective. I should mention, by the way, that this was another matter which was determined as a preliminary issue. That in this case, it was actually done by consent as opposed to ISOFT, where there was a contested hearing about whether or not that should happen. However, the success story doesn't lead on to this clause in the contract. So this is about the scope of liability and the question of whether or not, what actually, the difference between direct and indirect losses are. Now, the difficulty which is arising with this clause is effectively by a conflict of ideas in the two paragraphs there of this clause. So you've got on the one hand a agreement or an acknowledgement that the consultant is going to be liable for reasonably foreseeable losses which are caused directly by a breach. And that is pretty much liability for everything at law. That's pretty much what Hadley and Baxendale says you're liable for breach of contract. So what does that leave for the second paragraph? What is indirect, consequential, or special loss in those circumstances? And the other big clash which appears here is the difference between direct losses and loss of profit. Because just like the first paragraph can effectively gobble up everything, so can loss of profit, because most claims are about economic loss. These clauses have been found to be unsuitable for preliminary determinations. We'll go through some of the cases on this. And on that alone, I would suggest they're probably in that circumstance not fit for the purpose. So starting off, the first time that this concept of indirect and consequential loss was considered at a high level by the Court of Appeal in New Zealand was this case here, which will be familiar to many of you. I made a crack yesterday that it is the case which has probably been cited most often with the least effect in construction law anyway. For those of you who are not familiar with the case, I'll give you a very quick heads up on what the facts were. Essentially, Carter Holt Harvey and EC&Z entered into a contract. EC&Z agreed to build a cogeneration plant for use at Kinleith Mill. That's the boiler and the wood waste handling system you see on the right there. EC&Z contracted with Rolls-Royce to build the plant under an EPC contract based on FIDIC. Carter Holt said that the plant was defective, sued EC&Z's successor Genesis in contract, and tried to sue Rolls-Royce in tort. The Court of Appeal found that for the most part there was only a very limited duty of care and knocked out the majority of Carter Holt's claim against Rolls-Royce at a strikeout level. That's all very interesting, but what I want to talk about today was another strikeout application that was considered by the court, which was about the scope of the damages that Carter Holt was seeking and the effect of these two very abbreviated clauses, which picks up the key substantive terms. Carter Holt was saying, the plant's defective, we want the costs of repairing the plant. And everyone agreed that was a direct cost. But Carter Holt was also saying, while the plant isn't working, we're having to burn extra gas because the wood waste isn't working as it's supposed to, or we're having to buy electricity from the grid because the generator isn't available, or we can't make as much pulp and paper because the steam isn't coming through, and so we're suffering a loss of profit. And what Genesis said was, well, that's what loss of use means. What else could it mean? Revenue, profit, you can't claim that. Whereas Carter Holt's argument on the other side was, well, hang on, it's really obvious that if the plant's not working, we're going to suffer these losses. So they're clearly a direct loss. So that was where the two arguments were going. If you read through this part of the case, you will see that it circled very much about whether or not there was a commonly understood meaning for this time, direct, indirect versus consequential, which arose out of a series of English decisions, which at that time had also been approved in Australia, which split the difference between direct and indirect along the two limbs of Hadley and Baxendale, which roughly fall into losses arising directly and naturally in the ordinary course. And on the second limb, losses which arise in special circumstances, but because both parties know about them, they are reasonably foreseeable. So effectively, that knowledge pushes them into the first category. They flow naturally as a result of that. Now, this is a perfectly good test for saying what should be in a contract, but with all respect, and should be within a claim for damages. But with all respect to the English courts, it's completely lousy for working out what should be excluded by an exclusion clause or not. Because for the second limb, you're required to think, well, I do know about it, but if I didn't know about it, would it be in and out? Which is quite difficult to apply. And the consequences is that, typically speaking in these cases, the loss of profit which flows from the ordinary course of things has not been stopped. So the clause has not been effective to exclude loss of profit in those circumstances. Unhelpfully, the Court of Appeal said, well, we're not really sure what the parties meant, so we're going to require this to go off to trial for determinant. So they didn't decide the issue. And as a result, that case went on for another 5 years. There was a 10-week trial, settled after that. And there was, one would argue, a lost opportunity to get that settled at an earlier stage. Would it wouldn't? Who knows? But the lost opportunity was there. So you could say that that clause did not do what it was supposed to do. It was not fit for its purpose. Now, Hadley and Baxendale has not been applied. The split in Hadley and Baxendale hasn't been applied for clauses of this sort since. The words indirect and consequential are scattered and used throughout clauses of this type in contracts, not just in the construction field, but throughout. And to date, the courts haven't come down on a particular meaning. Effectively, what they say is you've got to look at what the intention is in the context of the particular contract. But the essential problem that we discussed at the start of knowing what the difference is between indirect and indirect hasn't really been resolved. Now, talking about one of the cases mentioned by Kelly just before, the CPB and WSP case, this was a case where the particular clause in the CCCS contract got a bit of a test run. If you have a quick look through that, you can see the wording is basically identical, apart from the fact that the first sentence has been made to apply to both parties rather than just the consultant. And this was the test of this particular clause. And again, depending on your point of view, the test, regrettably, or pleasingly for Kelly, was not passed. The judge said, look, I can't determine it on the basis of Hadley and Baxendale, because if you look at the first sentence, both types of losses are actually set out there as being direct losses and losses which are recoverable. So I'm going to look at this in the sense of what is direct and indirect as being what flows effectively in the ordinary course. And the type of losses that were being claimed by CPB in that case did flow from the ordinary course. They're obviously foreseeable. If you put forward a design which isn't up to scratch, there's a clear possibility that the tender will be underpriced and that particular loss will flow. So that went through. The judge did have to consider, the judge didn't really consider what the alternative was, what were the indirects, but he did have to confront the question of whether or not this was a loss of profit. Effectively, there was the lost opportunity to put in a higher tender, which would have got a better result. What he said was that actually this is a loss of revenue. And in the circumstances which Kelly's already mentioned, where CPB have made a massive loss overall, there was no profit in that. I have a few issues with that. I'm a business owner. Loss of profit to me means one of two things, a drop in your revenue or an increase in your costs. That's how you lose profit. And I guess there's also a question about whether or not when you interpret a clause which is applicable at the start, the fact that further down the track, there's a number of reasons why profit wasn't available. Is that relevant to interpretation or not? But I think what is important here is the fact that when you've got a direct liability which is being specified, which is all encompassing like this, the court's natural inclination is going to be to say, well, it's in rather than it's out. And that's exactly what happened. So despite my criticisms, it's not necessarily I'm saying that it was a wrongly decided decision. You can certainly see how the judge came to that. All right, this is a case I'm less fond of, it has to be said, than Kelly. But nonetheless, let's talk about the limitation clause in this particular contract. This was a different clause. This is a bespoke clause which had been worked out between Worley and Hawkins as they then were in a more than one contract. I think this was the third time it had been used. And there was evidence drawn at the trial about what the intentional purpose of this clause was to be, which was essentially that each parties would carry their own losses in relation to adverse outcomes in relation to the tender. And that's the reason for the scope of the very wide clause. Now, that's Worley's evidence. It was not accepted by the judge. But that was the reason, Worley said, for the extensive list of exclusions there: income, business, contract, anticipated saving, finance costs, operating cost increases, or any other economic loss. But importantly, you can see those words at the end, or for any indirect or consequential loss or damages. So they've put them in at the end, as indeed is a usual custom. That had a consequence that the judge said that colours all of the preceding types of loss. So she was willing to agree and accept that actually when we're talking about these types of loss, we're only talking about indirect loss. So it pushes it right back to the question of, well, what's direct and what is indirect? The top sentence there is, and I should say this is abbreviated, it's missing 2 paragraphs in the middle, is what caused the issue from Worley's perspective and what caused this clause not to be effective. Worley shall indemnify Hawkins from and against any claims, actions or proceedings and any loss, damages, costs, including legal costs and expenses. The judge said that this clause was apt to include claims for payment claims effectively for subcontractors for additional work that they had been instructed to do. That came within the loss, damages and expenses. So effectively, the first clause or the first sentence swallowed up the exclusions further down. She did deal briefly with profit, which was to say that in her view, that was the anticipated profit that Hawkins would have expected to make at the outset of the contract. I don't entirely disagree with that. What she means there is slightly ambiguous. I am extrapolating here, so this may not be correct, that what she was saying is that profit in those circumstances would be your margin on top of your subcontractor costs rather than the entire contract profit. And she also struggled a little with off-site and on-site overheads. She accepted that that might fall within the requirement for an exclusion of an increase in operating costs, but because she decided that the evidential basis for that claim wasn't there anyway, she didn't have to decide that point. So again, the clause was ineffective to exclude the claim that was being made. I should make the point that in both of these cases, there was a liability cap in both contracts. There was a $1 million cap in the Hawkins and Worley case, and there was 10 million, I believe, in the CPB and WSP case. And again, that has implications because if you've got an obligation or a liability and it's capped at $1 million or $10 million, the expectation is that you might be liable for something which is capable of reaching that kind of a level. So final thoughts here, indirect and consequential. We keep using these terms. Not doing what they're supposed to do and they're not helping. They potentially corrupt or constrain the other words of a contract. So please be very, very careful using them or don't use them. And the second message to really come out of this is that it is very important to explicitly identify both the included exposure as well as the excluded risks. And if you do that, there's a potential not only that it will be effective, but it might also be more enforceable at an earlier stage. So let's go back, for example, to the Rolls-Royce case. If that had said, if there is a breach by Genesis will be responsible for repairing the plant, but it will not be responsible for any losses which flow from Carter Holt being unable to use the plant or any aspect of it, or anything else we haven't thought of yet. It may have been more effective in those circumstances. All right, that's it from me.
Okay, well, I don't know how our timing is going. But we do have a little bit of time, I think, for some panel discussion on some of these issues.
So we'll do a Q&A, should we, now? Or do you want to do a bit of a discussion first?
Well, I'm happy to do Q&A, but if there's no Q&A, we've certainly got things we can discuss.
Okay, so can I suggest, have you got any questions on?
No questions.
No questions so far, but keep monitoring online and give me a shout if you have any. Perhaps we'll take questions from the audience, and then if there are not too many questions, you can carry on for the next half an hour or 1 hour, 2 hours. No, I'm
Oh,
kidding.
no.
Any
Half an
questions
hour.
from the audience? Anyone? To the panelists? Yeah, okay, we'll take, do you go back first or front first? So I can see you clear.
I was interested in how why you
Just give me a second. We need the mic, right?
Yeah, we've got a
for-
mic here.
Just-
Turn it on.
Just for the recording purposes, we must make sure that we get the question clear.
Interesting, I was interested in the CPB one with respect to the roading, because and the way that the risk was dealt with, if you like, or hadn't been managed. But I'm intrigued at what the client themselves was asking for in that, because I understand in those large contracts, the client actually expects the contractor to take every foreseeable and unforeseeable risk within their tender process. I'd be interested, and that extends to future government acts of Parliament, which may cause additional cost to the project, even though the government is theoretically the client. Be interested in your view on that. You know, you're talking about risk. It seems to me that the more risk that we place onto the contractor, we just find they price it, we pay far more money, and often that risk isn't eventuated.
I'll have a crack at that.
You have a crack at that now.
The example you cite, Brett, of possible legislative change in the future and the impact that might have on a project is something that a contractor has to price to the extent that they can. There will be a contingency and a number of risks that they identify in their price. Something I said last night to the, that's out of their control, but with reasonable confidence, they can predict that the government's not going to outlaw the use of bitumen or something like that, I suppose. But yes, there might be some allowance for that. But one thing there won't be an allowance for in the contingency and risk sort of provisions that a D&C head contractor makes is the risk that the design consultant who's being paid has got his or her design wrong. Because you're paying them to deliver a result. And in this case, it was one that complies with the PRs. Now, there was argument about that, but ultimately it's found that, yes, that was the obligation on WSP. So when you're paying someone to perform in that regard, you don't need to, and typically you never would, allow a contingency for them having got the design wrong. Because if you take that to its sort of ultimate position, what if every aspect of their design was wrong and the entire project had to be redesigned? There's no way you can actually price that kind of a risk. So if you're going to, the beauty of getting someone on board and paying them and knowing they're insured and all the rest of it is that you expect them to get it right, and if they don't, there are consequences.
If I can also, not necessarily follow on from what Kelly was saying, but talking to your point about the government in PPP projects, just tending to put all of the risk on the contractor and not take any of its own. I mean, you're right. I mean, this has been complained of publicly quite a lot. I think one of the answers is that there needs to be pushback, quite simply. If the government can't actually get somebody who's going to take all that risk for the price it wants, then, it's going to have to share some of the risk. It's going to do it, there just needs to be that pushback. And of course, that is difficult because you're in a competitive tender environment, aren't you? But, people will have read the Infracom report arising out of Transmission Gully, where they were talking about the affordability threshold and other pressures that the government was basically putting to drive contractor behaviour, and how that, sometimes the government's pricing practices and the government's tender practices just drive bad contractor behaviour. I think that there's not a lot you can do other than push back or decide I'm just not going to do it.
Yeah, and I understand what Kelly's saying with respect to the consultants, but it seems to me in these large projects, there's an incredible lack of knowledge about risk allocations and where it should actually lie. There seems to be, from what I've seen, this desire to indemnify yourself from any cost by pushing it all onto somebody else, whether it should sit there or not. And I think that's part of the reason why our infrastructure projects are such a mess in New Zealand and cost-wise, because we don't allocate risk properly. We don't actually hold it where it should be held so that we can minimise the cost of that risk.
To some extent, that does, as you say, lie at the principal level as well. And that's correct. But the only way to sort of get around that or to change that is push back from the contractors.
I mean, one of the consequences of transferring that level of risk is that, of course, it becomes uninsurable.
Okay, there's another question at the back.
We've got a question here.
Okay, yeah, we'll do. If you're right at the back, if you can just hang in there, just another quick question.
Christina, this one might be for you. If the council in the Tauranga City Council case was suing as a building consent authority rather than as an owner, would it have been possible that the limitation clauses in the producer statements would have been upheld, notwithstanding that, as you say, they were essentially non-contractual disclaimers?
Well, there's that law, a non-contractual disclaimer is perfectly good. So in theory, that should hold. So I'm actually quite fascinated to see whether it would or it would not. But effectively, if you've got it'll have a number of effects. First of all, it will raise the question about whether or not the council can rely on it and sue based on it. It also puts additional risk on the council themselves. Those of you who have staggered through the Gore Street judgment, you'll see that while the judge said that the council is entitled to rely on producer statements, they must do so, or they must take a reasonable and critical view to them. So in a circumstance where there is a limitation of that level, it was 200K, I think, from memory. Yeah, there may be additional query on the council about whether or not that's an appropriate thing to do. I understand this has been a standard feature of producer statements for a very long time though, so who knows?
Okay, there's one question online. Maybe we'll do the online question and then Melanie, someone had a question and then a fourth question here. Yeah.
Yeah, so we've got two questions online, so I'll just read the first one out now and we'll get back to the second one. Do you recommend using specials to strike indirect and consequential from the standard forms, or perhaps make them capitalized to find terms as a pathway to negotiation?
I think what really needs to happen is you make it very clear what you mean. If you want to use those terms and you can't let them go, if you can put additional words to say precisely what you mean, that will be of effect. I mean, if a clause is clear, the law has indicated that a judge will apply it. I mean, that's what ISOF said, and that has been followed through by the High Court since. The difficulty is that judges scratch their head and they say, well, what really do you mean? So if you identify both the directs and the indirects, you're much more likely to succeed. And now we've got the brave new word of Bathurst. If you've got, at the very least, correspondence going backwards and forwards, that may be of use as well.
So just to clarify the question there, so you would agree that it could be defined, and that would be
Sure, why not put in the specials indirect and consequential in the context of this contract means?
Yeah, and what I was going to say, just ask yourself what you think direct losses are. Do you mean out-of-pocket costs? Do you mean, the out-of-pocket costs of repairing the building? If that's what you mean, say that's what you mean.
Can I just offer my 2 cents on that? In the Worley case, the clause there that dealt with exclusion of potential liability and with the liability cap was about 5 or 6 subclauses long, and it had developed over time. It sort of bore the hallmarks of drafting by a committee, because it started out by saying at 25.1, whatever the first subclause was, that Worley would indemnify the contractor from losses that it would suffer and all the rest of it, and then it imposed a cap of $1 million, as Christina mentioned, and then it gets down to the bottom clause, which looked, at least to my eyes, as something that had been added subsequently, which said that neither party would be liable to the other for including a whole lot of things, but including any economic loss. Well, you can't reconcile those two clauses, other than in the way that the judge would have, it seemed to me, been inclined to do, which is to say, well, what you're talking about there is effectively second limb of Hadley and Baxendale stuff, and the first clause sort of prevails for any reasonably and fairly suffered loss that follows as an ordinary consequence from the breach. So lawyers start adding in words, they get all carried away, don't they? And start adding in more and more words, and in the end you're ending up with near legal gibberish.
So what you read, sorry.
I think the point that that Kelly's making is a fair one, that you can't have either taking up everything, because that doesn't make sense. The direct definition can't mean all losses, because otherwise why have you got exclusions? And if the effect of the exclusion is to take out all, then it needs to be very clear. And again, when you look at the authorities in relation to exclusion clauses as opposed to limitation clauses, although in theory you're still applying the same contractual principles, it gets even harder, because you're telling the court that there's going to be no liability at all.
And the other question online?
We've now got 3. So question 2 follows on directly, so that's quite useful. Christina, given your comments, brackets, criticism of the indirect and consequential costs clause, should ACE/Engineering New Zealand revise their clauses in CCS and the SFA?
If they want that clause to do something, yes.
Yeah, okay, the answer is yes. So in other words, CCS and SFA is due for a revision, especially given the new 3910 as well. Yeah, okay. Why do we do a couple in the audience back online? Melanie?
Sorry, can the contractor ever be found negligible for a design flaw due to being an experienced contractor and not picking up the design flaw? My first question. And my second question, where it was mentioned one of those cases that the damages were calculated based on the tender price. But if that's a variation to the contract and there wasn't an applicable rate, any bill of quantities or anything like that, then would the entitlement not have been to the actual costs and not based on what how the tender was priced?
Everyone's looking at me. Right. The first question, you're talking here about something that's gone wrong with the design in the context of the design that is set settled for the tender. And what you've got is party A, the head contractor, paying party B, the designer, to produce a tender design. Now, if there is something wrong with it, what the question seems to posit is a situation where the head contractor has been around for a long time and knows a good design when they see it, and somehow they should have recognised that this design was non-compliant with.
Yes, that's correct.
Pretty unusual factual sort of scenario. I would have thought you've got the reason that contract exists at all is because the design consultant is the expert who has the knowledge and expertise, and often they warrant that, as they did in at least one of these cases, to
If they're sensible, they don't.
but they often do because they're trying to win the job. And so you know, they line up in beauty parades and so on and say, we're fantastic, we design this kind of stuff day in and day out, trust us. And by the way, pay us $2.5 million or something for it as well. So it's would be a pretty unusual set of facts. I can't imagine off the top of my head where, notwithstanding that the design's faulty, the liability for that rests somehow with the head contractor. It's not a contrib neg type situation either.
It might be a contrib neg type situation, particularly if you had a head contractor who was very experienced in roading jobs and had engineers and roading engineers themselves who were part of their pricing team, and was totally capable. You know, you can see where a contrib neg argument could lie.
Melanie, is there another question at the back, or was there another question at the back? Otherwise, I'll go online again. Can we do the online ones?
Yep.
Sorry, the second part of the question was whether the loss should have somehow been priced as a variation, but that's to confuse the tender services agreement with the contractor's own agreement with the client. Completely different contract. And of course, almost certainly under the kind of scenarios that we're talking about here, there is no variation. There's no entitlement to a variation under the head contract. Sorry, not the head contract. Well, yes, the head contract,
Yeah, the head contract.
between client and head contractor, because from the client's point of view, literally nothing has changed. You, head contractor, promised to build me this thing for 192 million, whatever it is, and you still got to do that. And if your designer has fluffed the design somehow, well, that's on you, and you sort it out.
Online question.
Hi panel. Under 3910, the principal is responsible for the design. However, special conditions state that the contractor shall do a buildability check before the construction and identify any issues related to the design. If the contractor hasn't checked and later realizes the issue in the design, is the principal liable for the abortive cost and EOT?
Well, what do they check?
It says principal.
Checking for buildability.
So they're checking here for buildability, which and the ability to construct. And that it seems to me that is relatively limited. It's certain, and it depends whether I would not say that would impose upon a contractor the skill and expertise of a designer in terms of carrying out a design. It is not always going to be obvious from a contractor's perspective that a particular design may not be buildable.
I think it all really comes down to your contractual arrangements. And there's a lot of contractors out there who have consultancy and design experience and can sometimes be the contractor and sometimes be the consultant. So the knowledge can be within them, within that organisation in some circumstances. The issue with the warranty in particular, the difficulty is that you've got a strict liability outcome, which is provided for. You may be able to argue for contributory negligence if you've got a proportionate liability clause in your contract, but otherwise you're going to have real problems with contributory negligence in those circumstances. So it's going to depend about the divvy up of risk and what each party has agreed to do.
And take, for example, you know, a geotechnical problem. That a geotechnical engineer either doesn't know about or, you know, has made assumptions about the certain geotechnical conditions. So the geotech engineer has made assumptions about the geotechnical conditions. The structural engineer has done a design based on all of that. The builder has looked at the structural engineer's design and said, yeah, sure, I can build that. And the builder's right. I mean, it's you're not necessarily expecting the builder to have the geotech engineer's understanding of what the geotechnical conditions are. So I don't think that in all circumstances that buildability check is going to shove heaps, undue liability on the builder.
Okay, I've got the warning from the boss. Melanie keeps us all in check to make sure we're on time. It is now 7:35. No express extension of time request has been made, and I don't want to be in trouble, time being at large and so on. There's no liquidated damage anyway in the first place. It's all Helen Macfarlane kind of lost. So, right. So a few things to close off now. Anyway, if you do have any more questions, you can always come up to the panelists in a while. Right. So can I thank, first of all, Hesketh Henry for hosting us and providing the live stream, which I hope worked well for everyone online. I would also like to thank Jeff for hosting us in Hamilton, Emma in Dunedin, and Toby in Queenstown. And also we should thank Maltby's and Galloway Cook Allen support to enable these hubs with our members networking as well, all these various hubs. And thank you, of course, to Helen, Christina, and Kelly for your wonderful session here. And they've got some more. They haven't finished roles. They're going off to Wellington tomorrow, right?
That's right.
Yep. Okay. So we really appreciate your insightful presentation and also your commitment to a 3-day roadshow. Yep, we've got a gift for you in appreciation, as always. Let's do anyone.
You can have some.
Yeah, I know it. Men first, you know.
Thank you very much.
Thank
Melanie
you.
will give to the women.
Thank you very much.
And yeah, can we, through our normal show of hands, thank the speakers? It is now 7:37, 7 minutes overtime. And as always, we must thank Melanie for keeping us all into, seriously, she does a brilliant job and she does a lot of things behind the scenes, including on the set as well. So thanks, Melanie. Thank you very much. And just one little bit of announcement. You would know that this thing called NZS 3910-2023, which is out here. Just to share with you, at the moment, the committee is getting together again just for to look at the design and build contract. So that's imminent. And Gavin is here as well. They've all volunteered. All the committee, I think pretty much most of the committee members, except one who wants to retire off to the South Island, are willing to contribute to get the design and build version out as quickly as possible as well. We already got a first draft, I think, so that should come out soon. And one other thing I want to share with you, because I represent the Society of Construction Law at the drafting committee, I just want to share with you a bit of feedback. The committee is so dedicated, it's unbelievable. Having got feedback now, a few months of the contract being used in industry with a whole bunch of specials with some organizations and so on, we're actually meeting on Friday, purely voluntarily, to see, hey, what kind of feedback have you got from industry? And just to self-assess and so on. So I just want you to know that things are going on and the committee is very dedicated. Watch out for the, look out for the design and build. With that, let's call it a day and let's continue with a bit of food, I think. Thank you.